So on today's video podcast, I wanted to set forth some guidelines in drafting legislative statements in bills. I've talked in the past about the differences between legislative findings and declarations and legislative intent statements. And of course, bill drafters are very familiar with these distinctions. I came across a definition of the two in the Colorado bill drafting manual. Colorado describes them as the following. A legislative declaration statement is an explicit or formal statement or announcement about the legislation. A legislative intent statement indicates the intended purpose or aim of the legislation, or it may indicate the state of mind of the legislature at the time it is enacting the measure. So findings and declarations, such as those used in California legislation, may provide factual information or value statements about the subject being addressed in the bill. Or it could describe, for example, the problem the legislature is trying to address. And a legislative intent statement often includes a statement of the desired result of the proposed legislation. So, in writing either of these statements, the bill drafter should evaluate the purpose or including the legislative finding or declaration statement and or the legislative intent statement. Now, in some instances, these statements may be better saved for the bill fact sheet, committee bill analysis, rather than be included in the bill itself. While the bill's author can obviously choose whether or not to include these types of statements in his or her bill, the bill drafter should ensure the accuracy of the statements that are being included. And the bill drafter also needs to determine with the bill author whether to codify these statements or have them be uncodified. Now, legislative findings and declarations can often establish sort of a historical or factual basis to explain the purpose in enacting the proposed legislation. These statements should obviously be accurate. They can also be helpful if the author or the sponsor, or certainly the bill drafter, expects a possible legal challenge to the legislation, because often the courts do consider these official statements of the legislature. Legislative intent statements are likewise important for providing an explanation of the bill to the general public, maybe the regulated community, the executive branch in implementing the statute, or of course the judicial branch in interpreting it. As we know from statutory interpretation principles, whether the courts consider legislative declarations or legislative intent statements is based upon whether there's an ambiguity in the statute. The reason that some states frown upon the use of these types of statements is because they perhaps meritoriously believe that unambiguously drafted statutes don't need these types of statements or explanations. And the courts generally look to the legislative declaration or intent statement if there's ambiguity in the statute, in which case they might be used to construe the scope and effect of the statute or help them in their interpretation. Now, keep in mind that these statements or declarations are not to confer power or to determine particular rights under the law. So, drafters of these types of statements should ensure that the statements aren't viewed as creating a substantive right or a promise that the state will do something like fund a program. I also found in the bill drafting manual for Colorado this explanation. A legislative declaration or legislative intent statement should serve a legitimate purpose, and statements that serve other purposes should be avoided. Their manual in Colorado also points out that a statement should not be characterized as legislative intent when it really instead is a legislative declaration or vice versa. Now, when drafting either of these two types of statements in a bill, the drafter again wants to ensure that they accurately reflect the contents of the bill. And also, there should be a logical connection between the desired result and the reasons that are stated in one or both of those types of statements. So, decide what the purpose of the statement is, and then make the words accomplish the desired purpose. Now, in many instances, bill authors are given free rein to draft their legislative findings and declarations, and even sometimes their intent statements, of course. I'm a believer in states and their bill drafters to verify the statements for accuracy and whether or not they're factual. Because if we're going to have courts rely upon these types of statements, then obviously, at least in my mind, they need to be correct. In fact, I'm aware of at least one trial court in the state of California that looked behind the statements of legislative intent that were contained in the bill, and they actually found them not to be accurate. And so they were disregarded for purposes of interpreting the bill. And a deputy attorney general on behalf of the state was defending the statement and the statute itself underlying. And the trial court dismissed their arguments because of the inaccuracies in the legislative findings and declarations. The drafter also wants to ensure that these types of statements are not ambiguous. They should really be clear and concise, and be clear statements in the bill. You also don't want, however, these types of statements to be any bit of a substitute for your um, accurate bill drafting. As I've discussed, a legislative finding or declaration or a legislative intent statement should not create any rights or even prohibit any types of actions. Again, they're not intended to create substantive law. That should be left to the actual statutory provisions being amended or added by the bill. And so we should really look for a truly legitimate reason for including any of these types of statements. Again, the courts rely upon this sort of information if the statute itself is ambiguous. So I do agree with a lot of other states that say these types of statements are unnecessary if your statute is not ambiguous. A lofty goal, perhaps, but certainly something to keep in mind with the legislative bill drafter.